The moment Bondi refused to look at Epstein's survivors, she was 3 feet away from them, not across the country, not in a different building, not separated by lawyers and legal filings and sealed court documents. 3 feet. The women who had survived Jeffrey Epstein's trafficking network had walked into that congressional hearing room, taken their seats directly behind the witness table, and waited. They had traveled from different states. Some of them had never spoken publicly before. Some of them had spent years in courtrooms fighting for the right to be in that room at all. And they sat there quietly, and they watched Pam Bondi settle into her chair, arrange her papers, and prepare to face the United States Congress. And for the entire duration of what followed, Pam Bondi never looked at them, not once. That is not a characterization. That is not a political interpretation. That is a physical fact, documented on camera, witnessed by everyone in that room. The Attorney General of the United States sat 3 feet away from the survivors of one of the most extensively documented sex trafficking conspiracies in American legal history, and she could not bring herself to turn her head. Everything that happened after that moment needs to be understood inside that frame. Because the words said in that room can be disputed, legal arguments can be reframed, testimony can be walked back by press offices working through the night, but you cannot spin a direction. You cannot dispute where someone's eyes were pointed. And for hours, in front of cameras, in front of Congress, in front of the survivors themselves, Pam Bondi's eyes pointed everywhere except backward. That single fact tells you more about what happened in that hearing room than any transcript ever could. But the transcript still matters. So let's go through it. Pam Bondi walked into that room carrying something unusual for an attorney general testifying before Congress. She didn't carry a legal brief. She didn't carry a prepared defense of her department's document handling decisions. She carried a 3-ring binder, and the binder was not full of answers. The binder was full of attacks. Her staff had spent their preparation time compiling personal jabs, pre-written insult lines, carefully researched political ammunition aimed at the Democratic members of the committee who would be asking questions about the Epstein files. The nation's top law enforcement officer, appearing before Congress more than 50 days past the legal deadline for delivering the complete Epstein file disclosure, had chosen to prepare comedy roast material instead of legal justifications. That choice is itself a statement. When you cannot defend the thing you did, you attack the people asking about it. When you cannot explain why the law wasn't followed, you read an insult off a piece of paper and hope the room moves on. The room did not move on. The law that required the Epstein file release was not complicated. Congress had passed it. The president had signed it. It specified exactly what had to be delivered, what could be redacted, and when. The only permissible redactions, the only ones the law allowed, were to protect identifying information about victims and survivors. That was the legal standard. Protect the people who were trafficked. Protect the names, the photographs, the personal details of the individuals Epstein's network had targeted and abused. What the Department of Justice did was the opposite. When the files were released, lawmakers who reviewed them found something that defied the plain language of the statute. The names of men identified as co-conspirators in Epstein's trafficking operation, individuals the federal investigation had specifically documented as participants in his network, had been redacted, protected, hidden. And the identifying information of the victims, the people the law was written to protect, had not been fully shielded. Their details, their names, information that could expose them publicly, had been left visible while the men connected to their abuse remained anonymous. The room went quiet when that finding was presented. A lawmaker asked Bondi directly how that had happened, how the redaction decision had been made that way, how the legal standard had been reversed so precisely, protecting exactly the people the law did not protect and exposing exactly the people the law was designed to shield. She opened the binder, not a legal explanation, not a procedural account of how the review process worked, not an acknowledgement that the outcome required examination. She read from the binder, an attack line about something else entirely, a deflection so complete and so practiced that it suggested this was not the first time she had used it. The question was asked again. She read from the binder again. That exchange repeated itself with a consistency that became its own kind of answer. Every question about the Epstein files produced a pivot. Every request for a direct response produced an attack. Every attempt by a lawmaker to hold the hearing to its purpose produced the binder. And somewhere behind Bondi, in seats that she never turned to acknowledge, the survivors watched all of it happen. Then came the video. A member of Congress had obtained footage, clean, time-stamped, unambiguous footage, of the FBI director under oath. In the clip, the director was asked how many times Donald Trump's name appeared in the Epstein files. The director said it wasn't 1,000 times. He was specific. He was confident. He said the number people were suggesting was misleading. He said no. The lawmaker paused the footage and then presented the actual number. Over 1 million times. Donald Trump's name appears in the Epstein files more than 1 million times. Not according to the lawmakers' estimate. According to a member of Congress who had personally traveled to the Department of Justice, sat in a secure room, and reviewed the unredacted materials himself. 1,000,000 references. And the FBI director, under oath on camera, had said the number wasn't even 1,000. The room absorbed that for a moment. The implication was not subtle. If the FBI director had testified under oath that the number was not 1,000 and the actual number was over 1,000,000, then the FBI director had committed perjury on video in front of Congress. And the person sitting at the witness table was the Attorney General, the head of the department responsible for prosecuting perjury. The room asked what she intended to do about it. She said the Trump presidency was the most transparent in history. A lawmaker told her plainly, "I believe you just lied under oath." And Bondi's response, the response of the nation's chief law enforcement officer to a direct accusation of perjury made in a congressional hearing, was this: "Don't you ever accuse me of a crime." Read that sentence again. Not, "That is factually incorrect." Not, "Here is the documentary evidence that contradicts that claim." Not, "I will refer this matter for review." The response to being accused of a crime was a warning. Don't say that again. Don't say that to me. Don't you ever. In a courtroom, an attorney would call that non-responsive. In a hearing room with cameras running and survivors watching from 3 feet away, it is something else. It is a signal. It is the sound of someone who has run out of answers and is left with only the threat that they are still powerful enough that the question should not have been asked at all. The hearing produced something else that the binder could not address. Lawmakers asked the survivors present in the room to participate in a demonstration. They asked those who had reached out to the Department of Justice, who had offered testimony, who had offered evidence, who had tried to give Bondi's department the material it needed to pursue justice for what had been done to them, to stand. Every survivor stood. Then lawmakers asked how many of those survivors had been ignored or denied by the DOJ. Every hand went up. And then, after everything, after the reverse redactions, after the binder, after the FBI director's apparent perjury, after 54 days past the legal deadline, lawmakers asked one final question. Despite all of it, how many of the survivors in that room were still willing to speak with the Department of Justice? Every hand stayed up. Every single one. They were still willing. After years of fighting, after having their own information exposed while their abusers were protected, after watching the Department of Justice prepare insult lines instead of legal justifications, after seeing their case handled as a political liability to be managed rather than a crime to be prosecuted, they raised their hands and said they were still willing to try. And Pam Bondi still would not look at them. A lawmaker asked her directly, turned to her at the witness table and said, "Look at the survivors. Look at the women sitting behind you. Acknowledge that they are in this room. Acknowledge that they exist. Acknowledge that you see them." Bondi stared forward. The request was made again. She stared forward. What does it mean when the Attorney General of the United States cannot turn around? It is not a difficult physical motion. It is not a legally complicated act. It does not require preparation or legal review or staff approval. It is the act of turning one's head and acknowledging the presence of another human being. And Pam Bondi, for the entire duration of that hearing, found it impossible to perform. The answer to that question, the only coherent answer, is that looking at them would have made the reality of the situation inescapable. Not for the cameras, not for the lawmakers, for her. You can read from a binder without feeling what is happening in the room. You can deflect and pivot and attack without processing the weight of what you are being asked to defend. But you cannot look at a survivor and keep doing that. The binder stops working the moment you turn around. The attack lines dissolve. The deflection becomes impossible when the actual human cost of the decisions you are defending is sitting directly behind you, looking at the back of your head, waiting for you to acknowledge that they are real. She never did. The hearing ended. The cameras packed up. The legal teams gathered their materials. Bondi's staff collected the binder, the 3-ring binder full of attack lines that had served as the Attorney General's entire defense strategy for one of the most consequential congressional appearances of the modern era. And the survivors were still in that room. The law that required the complete release of the Epstein files did not expire when the hearing ended. The 54-day deadline did not retroactively become satisfied. The co-conspirators whose names were redacted in violation of the law's explicit standards remained protected. The victims whose information was exposed in violation of the law's explicit protections remained exposed. The FBI director whose apparent perjury was documented on video and presented to the Attorney General of the United States remained in his position. Nothing changed. Except that now there was a record, a public, on-camera, documented record of what happened when the survivors came to Washington and sat in a room and waited to be seen. A record of what the Attorney General of the United States did when she had the opportunity to turn around. A record of what she brought to that hearing instead of answers, and what she chose to do with the hours she was given, and what she said when she was accused of lying, and what she didn't say when the survivors raised their hands and told her they were still willing to help. The record exists now. It cannot be redacted. It cannot be sealed. It cannot be coded as duplicative and filed in a vault where no one will look at it until a subpoena forces it into the light. It is already in the light, every second of it, the binder, the wrong number, the warning not to accuse her of a crime. The hands raised by survivors who had every reason to stop trusting and chose, against all evidence, to keep going. And the back of Pam Bondi's head, facing forward, for the entire time. 3 feet away from the people she refused to see. Let's talk about the architecture of what was hidden. Because the binder was a symptom. The refusal to look was a symptom. The real story is what those survivors were fighting to expose and why the Department of Justice had built an entire system of bureaucratic machinery designed to keep it buried. The Epstein investigation was not a closed chapter before that hearing. It was never closed. Federal investigators had spent years accumulating millions of pages of documentation, financial records, travel logs, communications, witness statements, the names of individuals who had used Epstein's network. Wealthy, connected, powerful individuals whose associations with what he ran had been documented in detail by federal agents doing their jobs. Those documents existed. They had always existed. They sat in government vaults. And the law had finally, explicitly demanded their release. And when the deadline came, what emerged was not the complete record Congress had demanded. What emerged was a managed version, a curated version, a version in which the redaction decisions appeared to have been made by someone with a very specific interest in which names remained visible and which names disappeared into black bars. The 86-page prosecution memo was the detail that the room kept returning to, a document prepared by prosecutors in the Southern District of New York, a document that contained the evidentiary case against Epstein's co-conspirators, a document that named names and laid out conduct and built the legal foundation for charges that were never brought. That document had been found by a lawmaker who traveled personally to the Department of Justice to review what had been produced. It was still redacted, still hidden, even from members of Congress who had the legal authority to see it, even after the deadline had passed, even inside the official disclosure that was supposed to represent compliance with the law. What is in those 86 pages that cannot survive public exposure? Bondi opened the binder. The draft indictment from Florida was worse. Federal prosecutors had prepared a formal charging document. Names, charges, evidence. The legal architecture of a prosecution that never happened. It sat in a file somewhere in the Department of Justice, and when Congress demanded the complete Epstein record, that document was still redacted. Still protected, still unavailable to the lawmakers who were trying to understand why the most extensively documented sex trafficking conspiracy in American history had resulted in precisely 0 prosecutions of anyone other than Epstein himself and his convicted co-conspirator Ghislaine Maxwell. The survivors in that room knew the answer to that question. They had lived it. They had been told for years that there wasn't enough evidence, that the investigation was ongoing, that the legal process required patience, that justice was coming. And then they watched the Department of Justice close its investigation into Epstein's clients in July of the previous year, issuing a memo that said prosecutors had not found evidence sufficient to pursue charges against uncharged third parties. A memo that was released while an 86-page prosecution memo and a draft Florida indictment sat in redacted files that Congress had not yet been allowed to see in full. That sequence, the closure of the investigation followed by the discovery of the hidden prosecution documents, is what brought them to that hearing room. That is why they traveled to Washington and sat behind the witness table and waited for the Attorney General to turn around. She never did. There is one more thing that happened in that room that needs to be said plainly. A lawmaker presented evidence that the FBI had received a witness statement from an individual who described overhearing a conversation between Donald Trump and Jeffrey Epstein. This witness had contacted the FBI's National Threat Operations Center. They had provided a statement. They had placed themselves on record as a potential source of information about the president's relationship with the man at the center of the trafficking network. That witness had never been interviewed by the Department of Justice, not once. The statement sat in a file, and no one from Bondi's department had picked up a phone or sent a letter or made any attempt to speak to someone who had voluntarily come forward with information about the most politically sensitive case the department was handling. Bondi said there was no evidence. A lawmaker said, "I believe you just lied under oath." And the warning came again. Don't say that. Don't accuse me of that. The survivors heard it all from 3 feet away. This is the thing about what happened in that room that the normal political coverage cannot fully capture. Congressional hearings happen all the time. Officials testify. Questions get asked. Non-answers get given. Committees express outrage. The news cycle moves on. It is a rhythm that Washington has performed so many times, it has become its own kind of theater. With known roles and predictable outcomes, and everyone understanding that the purpose is not always to find truth, but to create a record of having demanded it. But this hearing was different in one specific way. The survivors were there. They were not abstractions. They were not statistics in a federal filing. They were not case numbers in a docket. They were human beings who had been trafficked through a network of powerful men, who had spent years watching those men face no consequences, who had watched investigation after investigation stall and close and produce nothing, who had read the news coverage of the document releases and seen their own stories buried in redactions, while the names of the men connected to their abuse remained protected by the very department that was supposed to be fighting for them. And they still came. They still traveled to Washington. They still sat in that room. They still raised their hands when asked if they were willing to help.
That is not a political act.
That is not a partisan gesture. That is something that exists entirely outside the binder and the attack lines and the deflection and the wrong numbers and the warnings not to accuse. It is the persistence of people who have every reason to stop believing and choose, despite everything, to keep going. The Attorney General of the United States looked at the cameras. She looked at the lawmakers. She looked at the binder. She looked at the ceiling, the table, the middle distance, the aide standing near the door, every point in that room that was not the 3 feet behind her where the survivors were sitting. The files are still due. The 86-page memo is still redacted. The draft indictment is still hidden. The FBI director's apparent perjury is still uninvestigated. The co-conspirators' names are still protected. The witnesses who came forward are still uninterviewed. And the survivors' hands are still raised, 3 feet away from a woman who never turned around.